The Senate Committee on Judiciary will come to order. Madam Secretary, please call the roll. Present.
Senator Orenshaw,
Here.
Senator Lang, Senator Wynn, Senator Hansen, Senator Krasner, Senator Ellison, Chair Scheibel.
Thank you, Madam Secretary. Please mark Chair Scheibel as absent excused. Please let the record reflect we do have 7 members present. We do have a quorum. Good afternoon, everyone. Welcome to the Senate Committee on the Judiciary. Appreciate everybody joining us on a Friday. We do have 2 items on the agenda for today, Senate Bill 275, followed by public comment. We will be taking them in that order. We do have our Majority Leader here now, and at this time I'd like to open up the hearing on Senate Bill 275. Welcome, Majority Leader.
Thank you, Mr. Vice Chair and members of the committee. I appreciate the indulgence and apologize for the tardiness. My tiny one is ill and unable to be in daycare today, so we were trying to get him down for a nap before starting the hearing. So I appreciate the indulgence and sorry to keep everybody waiting. But I am very proud today to bring to you Senate Bill 275, which revises provisions relating to domestic relations. And we have a few folks I think who probably will be able to present the bill with your indulgence, Mr. Vice Chair, and then be able to answer any questions that you may have. And I may need to have some additional backup on the question part as well. So we've got lots of folks. Senate Bill 275 really does represent a crucial step toward protecting the most vulnerable among us, our children. Caden's Law, as this is commonly referred to in the many states in which it has been proposed, was named after Caden Minusco, a bright and loving 7-year-old girl from Bucks County, Pennsylvania, who tragically lost her life due to a preventable failure in the family court system. Caden was murdered by her father during his court-ordered unsupervised parenting time. Her mother, Kathy Sherlock, had previously submitted evidence to the court of the father's abusive, violent history, including criminal records and a protection order for having threatened to kill family members. A professional recommended that he be required to have mental health treatment before receiving unsupervised access, but he was nevertheless granted unsupervised contact with Caden. During that unsupervised contact time, the father beat Caden to death, leaving a note of retribution on her body, and then killed himself. Her case, like far too many, highlights the urgent need for reforms that prioritize child safety above all else. Caden's Law seeks to strengthen protections for children in custody disputes by ensuring courts prioritize the safety and the well-being of children. It encourages states to adopt stricter guidelines when making custody decisions, particularly in cases involving domestic abuse. This law promotes better judicial training, increased use of expert evaluations, and restrictions on granting custody or unsupervised visitation to parents with a history of abuse. The heartbreaking reality is that children are too often put in harm's way due to outdated legal frameworks that fail to recognize the dangers of abusive relationships. Caden's story is unfortunately not unique. Many children in the United States, estimates are in the tens of thousands, have been put at risk and even killed by a dangerous parent, often after a family court rejected safety concerns voiced by a protective parent. Furthermore, it is well documented that abusive parents frequently use family courts as a means of continuing their abuse post-separation to hurt and control their former partners by taking away or harming the children that they share. The Keeping Children Safe from Family Violence Act, or Caden's Law, within the Federal Violence Against Women's Act, or the VAWA, as we'll probably refer to it, incentivizes states to improve their child custody laws to better protect at-risk children. by restricting expert testimony to only those who are appropriately qualified to provide it, limiting the use of reunification treatment, promoting evidence-based ongoing training to judges and court personnel on family violence, and requiring that when family courts make visitation time decisions, they consider past evidence of abuse, including protection orders, convictions, and arrests for domestic violence or child abuse. Before I turn it over, I am going to do a brief walkthrough of this section-by-section overview of the bill. And so sections 3 and 4 contain definitions for child custody proceeding and domestic violence. Section 5 defines the term reunification treatment to mean a treatment or therapy aimed at reuniting or reestablishing a relationship between a child and an estranged or rejected parent or some other family member of the child, and prohibits a court from issuing an order requiring a child to receive reunification treatment unless there is proof it is safe, effective, has therapeutic value, and will not harm the child. Section 5 also prohibits a court from removing a child from a parent or litigant or restricting contact between a child and a parent or litigant for the sole purpose of improving deficient relationships between the child and the other parent of the child under certain circumstances. Section 6 provides that in a child custody proceeding in which a parent is alleged to have committed domestic violence or child abuse, expert evidence relating to the alleged domestic violence or child abuse may only be admitted by a professional who possesses demonstrated expertise and clinical experience. Section 6 also requires the court to consider evidence of past domestic violence or child abuse and prohibits the court from issuing an order to remediate the resistance of a child to have contact with a parent alleged to have committed domestic violence or child abuse. Finally, Section 7 requires each judge who presides over a child custody proceeding and certain other persons who have regular and routine contact with persons involved in child custody proceedings to complete training related to domestic violence and child abuse that complies with VAWA. Now, I would like to turn it over first to one of my co-presenters, Min Nguyen Long, and her sons. I also have Daniel Pollack, Policy Manager for the National Family Violence Law Center at George Washington Law, available via Zoom, and Marshall Willick of the Willick Law Group, who has extensive experience in family law, who are available in Las Vegas, I believe, to answer questions. With that, Mr. Vice Chair, what I would like to do first is to turn it over to Min, and then I think that she has her children who would like to just make a brief comment to the committee. Now that microphone is on, so introduce yourself and spell your name.
My name is Min Luong. It's Minhluong. I am a safe, protected parent. Currently, there is a major flaw in our family law system. Children are forced into having relationships with both parents after the marriage ends, no matter how broken and abusive the relationship is. Whether or not these judges believe there is abuse, they still force the relationship. They go so far as to completely cut off all communication between a parent and a child in a healthy relationship and force a relationship with the abusive one. When the violence and living conditions became unbearable, my children refused to go back to their father. I was then accused of alienation. The judge came up with a scheme to trick my kids. She had my assistant take my kids to Yogurtland, where they were fooled into believing that I was going to meet them for yogurt. But instead, their father arrived at the scene. What happened next was described to me by my assistant as a kidnapping scene in broad daylight. The children screamed for help in a parking lot of Yogurtland, while the father dragged my son, Matthew, out of my assistant's car and tossed him into his van. He then
Ma'am,
punched.
I apologize to interrupt you. If I just may ask you to just get a little bit closer to the microphone so that our team can capture everything you're saying. Please continue.
He then punched Matthew in the face, causing his glasses to fall onto the floor of the van. The father then proceeded with dragging my oldest daughter, Hannah, out of my assistant's car, scraping her leg on the ground as he tossed her into his van and drove off. This was what the judge ordered. They spent the weekend at the father's house, and the abuse continued. When they were returned to me, Hannah's body was full of bruises. The children told me what their father had done to them. I submitted their story to the court, and I was told by the judge that my children made up all those lies. When Hannah's psychiatrist saw the bruises on Hannah's body, and after listening to Hannah's story, she reported the father to CPS. When asked in court, the psychiatrist also testified that there was no alienation being done. Our judge looked the other way and ignored the report the psychiatrist who spent countless hours with Hannah presented. Since our judge already had alienation on her mind, she ignored what the treating medical doctor was saying and assigned the kids to a new psychologist, Sunshine Collins, who she knew would tell her what she wanted to hear instead. Collins never met all of my children or I, did not consult with Hannah's treating psychiatrist, didn't care to take time to take adequate family history and interview everyone involved. Collins instead made a recommendation for the children to go through a reunification camp in New York, supporting what was already recommended by the judge. Currently, court professionals are not educated on child abuse. The guardian ad litem and the opposing attorney refused to believe that the children were being abused. They stated, "There is no way the father would be doing all that during litigation." She also chose her father's right to own the children rather than really looking out for the best interest. She thought the kids were just going on a vacation with their father and it was somehow magically going to fix their relationship. Currently, too many court professionals, judges, guardian ad litem, psychologists, and attorneys are not trained to recognize abuse, or like I mentioned previously, they have this guideline that they feel obligated to follow, so they are going to force the broken, abusive relationship to work at the expense of the children's safety and mental health. I hear too often the court professionals claiming that they are acting in the best interest of the children, but instead they were acting in the best interest of the abusive parent. Had the guardian ad litem cared to look out for the best interest of my children, she would have listened to their concerns and wishes. She would have spent time doing her own independent research into the harms that these reunification camps can cause. She would not have recommended them to be with the abuser, where they continue to be subjected to more abuse. These children were not protected by the court, by the guardian ad litem, or the local psychologists. When there is a conflict between the best interests of the children and the rights of the parents who have a relationship with their children, the best interests of the children should always be the primary goal. When the children report abuse, when the child psychiatrist reports abuse, the children's safety should be the primary and only duty of the court and its professional to protect. What sick treatment this court professional did to my children, subjecting them to their abuser and removing me, their protected parent, from their lives completely. Imagine a rape victim made a report to authorities. Instead of protecting the rape victim and punishing the rapist, the victim was sent to live with the rapist. What psychological damage will come to that victim? How can my children grow up to believe in the justice system after this if we don't fix it? The problem is not just happening in our state, but it is a global issue. Far too many parents cannot afford the expenses of appeal attorneys to fight to get their children back. Far too many children are currently being subjected to live with people who have violated them one way or another. Far too many children have been killed by the abusive parents, even after the protected parents reach out for help from the court. My children, who are victims of the current family law, would like to share their stories. Thank you for allowing us to shed some light on these issues.
And thank you for joining us today and sharing what's obviously a very personal and difficult story of yours. Thank you. Would you like for your children to join us now?
Yes.
So we will switch sheets, if that's okay with
Please.
you, Mr. Vice Chair.
Is there anybody else wishing to join us? If you want to step forward. Hi, and I'm just going to ask that when you're speaking, if you could just get really close to the microphone just so we can capture it for minute purposes.
Thank you.
Thank you for joining us. Whenever you're ready.
Thank you for allowing me to share my story so other innocent children won't have to go through me and my siblings did.
And I'm sorry to cut you off. I'm just going to ask you if you could, before you start reading your statement, if I could have you just state your name for the record and spell it, please.
My name is Hannah Vahey, Hannah, and then Vahey. Thank you for allowing me to share my story so other innocent children won't have to go through what me and my siblings did. Growing up, it had always been our mom taking care of us, and we were bonded to her more than our father due to him being hardly around. When our parents split up in 2019, they agreed to split the time evenly. It was very difficult for us to be away from our mom and to live with our father because he was like a stranger to us. When we started refusing to go back to his house, he punished us for it. He became more and more violent each time. On multiple occasions, it had gotten so violent it had become life-threatening. The one time that stuck out to me was in fall of 2021. I was so scared for my life, so I screamed for my help, and my brother Matthew came to help me. My father then grabbed Matthew and started strangling him instead. I was so scared he was going to kill him, so I did everything I could to get us free, and we ran back to my room. During the next therapy session with my psychiatrist, she saw the bruises on my body and reported my father to CPS. This was not the first time he had been reported to CPS, and yet they still hadn't done anything to help us. My mother reported our abuse to our guardian ad litem in the court. Instead of believing us and protecting us, the judge blamed our mother for our resentment towards our father. They stated we made up the story and it was because our mother forced us to say that our father had abused us. They had continued to try to make us believe that there was nothing wrong with our father and that he had never abused us. The judge accused my mother of parental alienation and forced us into a reunification camp across the country. Cadence Law was passed in March of 2022, but it was not soon enough to save us because our state has not yet adopted Cadence Law. We were taken to the reunification camp April 8th of 2022. During the reunification therapy in New York, the social worker Linda Gottlieb assaulted me and my father continued physically abusing me. They had locked me and forced me to stay in a hotel room with my father where the reunification camp was held. As a result of the reunification therapy, I was taken to a children's hospital for 72 hours. The temporary order with no real end date didn't allow us to have any form of contact with our mother. We were forced to be isolated from everyone. Our source of comfort was completely removed of us. When we eventually went back to Nevada, I fought to go back to my mom every day. I didn't care for my health and I was having suicidal thoughts because I thought I would never get back home. Eventually, I'd have enough and ran away back to my mother's house. They didn't know where I was for almost 2 days until my mom had come back home and we finally saw each other again. When I ran away back to my mom's house, I brought a recording my father had taken on his phone of him abusing us, and I gave the recording to my mom. My mom tried to submit the recording to the court, but the judge wouldn't allow it. When I found out that they didn't accept it, I couldn't believe it. I finally had hard evidence against him, and they refused to accept it. The court chose to protect my father from the law rather than protect us from abuse. It wasn't until my mom appealed to the appeal court did the district judge release my siblings back to my mom. None of us deserved the treatment that was forced upon us. Had the guardian ad litem and the judge been educated about child abuse? Had they placed our safety over our father's parental rights? Had they really looked out for our best interests, then maybe we wouldn't have to go through such trauma. Our father physically, mentally, and emotionally abused us, and the court helped him do it. No child should be separated from the parent they are bonded to live with their abusive parent. Please pass Bill SB 275 to protect other innocent children. Thank you.
And thank you for sharing your story along with the comments that I made to your mom. It's important because you're hopefully going to help other folk in your situation. So thank you. Please, whenever you're ready.
Children in the state are currently being...
And right in front of the microphone, there's a little button. I don't know if you see it. And then before you read your statement, I'm going to have you say your first and last name. And then if you could spell it for the record, please.
Okay. Hi, my name is Matthew Vahey, Matthew. Children in this state are currently being treated worse than prisoners. In 2022, my sisters and I resisted going to my father due to his abusive treatment. He thought he could convince us to forget that our mother was our primary caretaker. She was everything to us. He thought that he could convince us that he never pushed my mom, hit us, held us down, arm choked us while we screamed out for help. To cure this alienation disease that he accused my mom of, I was held captive for 10 months against my will and held in solitude. cut off from all contacts of my mother and her side of the family as if they never existed. I was subjected to my abuser 24/7. Yes, this was a state-sanctioned punishment to me and my siblings for speaking about how the abuse and for preferring to be with a more nurturing parent. In addition, food was withheld from me for 8 months as a form of punishment since I did not want to have anything to do with my captor. Even prisoners are allowed to have one phone call. I was not even allowed to say goodbye to my mother or to the people I love. Even prisoners are allowed to have visitations. I was not allowed to have any visitations from anyone on my mother's side, including my mother. Yes, this is the cruel and unusual punishment that this state sanctioned. Instead of removing us from the source of harm and protecting us children, the unjust court professionals thought of an archaic, unproven, unscientific therapy and tried out a therapy where they thought we would eventually adopt Stockholm Syndrome and somehow will eventually tolerate my father again. The judge forced us to be brainwashed by Linda Gottlieb, a woman who ran the reunification camp that I had never met before. During that trip, Linda Gottlieb and my father continued to inflict pain on my oldest sister, Hannah, in the hotel where this reunification camp was held. On that trip, I witnessed both of my sisters having to sleep on the bathroom floor of the hotel. I witnessed Linda Gottlieb punching my sister in the chest. I witnessed my father holding my sister by her ankles, dangling her upside down and tossing her into the bathroom. I feared for my sister's safety and reached out for help in secrecy. The police eventually arrived. After this trip, we were forced against our will to stay with our father with no contacts from my mother for what was said to be 90 days. I could not take it anymore, and suicidal thoughts were the only things I could think of. Fearing for my life, the Guardian ad litem made multiple reports to CPS. Those reports were continued to be ignored by the court. It wasn't until my persistent mother and her attorneys made multiple appeals to the Supreme Court, my younger sister and I returned to my mother. Under my mother's guidance, I am now a 4.2 GPA freshman on track to finish high school 1.5 years early. Even though we are minors, we have the ability to know who harms us and who protects us. Our safety and best interests should be the priority when deciding custody of children. Our wishes and concerns should be heard and taken into consideration above all else. I ask you, the people with the power to make this change, please stop subjecting children with cruel and unusual punishment. I know that it comes with a certain risk for me to stand here and speak about this, but I could not be silent. Thank you.
And same thing I told your sister. Thank you for joining us. Do you see the button right beneath the microphone? Yeah, and if you want to grab that mic, you can adjust it. See how mine moves? Yours moves too. Yeah, you want to put it really close to you. And if you could say your name first, and then you can read your remarks, please.
Selena, Selena, Vahey, Vahey. Hi, my name is Selena. I'm turning 11 years old today. When I was 7, my siblings and I were taken away from our loving mother and forced to go through reunification camp, where we were forced to go to New York. I'd like to share with you my recurring nightmare that I still have after 4 years as a result of this camp. In my nightmare, my mother was taken away from us. My siblings and I were kept in dark, separate cages away from each other. In my nightmare, this Linda Gottlieb woman who ran the reunification program kept on walking around our cages. I was not allowed to see my siblings. It was just darkness everywhere around me. After some time has passed, my siblings were taken away, and I never saw them again. I couldn't handle it anymore and finally escaped. I traveled across the ocean to find my mother, but when I eventually found her, so much time had passed, and my mother could no longer recognize me. Even after all that effort, the police came and took me away forcefully from my mother again. No matter how many times I've dreamt this, I always wake up in tears. Why do I keep on having these nightmares? During the reunification camp, I was told by my father and Linda Gottlieb that if I was to ever talk to my mom again without their permission, then my mom will be taken away from us forever, and my siblings and I will not get to live with each other, as we will all be split up to live with different families, and I won't get to see my siblings ever again either. My mother did nothing wrong. All she did was take care of us and protect us. My mother didn't want me to speak today, but I begged her to allow me to have my voice heard. I'm here today to tell you my story so that no other children should have to live through what my siblings and I did. I was only 7, but I was forced to live in a very traumatic environment when I was with my father. I witnessed the violence that my father did to my siblings. I witnessed the constant yelling and the tears that were shed by my siblings. My mother was my world, and it was taken away from me for months. No children should have their loving, caring parent taken away from them. Please pass SB 275 to prevent other children from experiencing what I have experienced. Thank you.
And thank you for joining us. All right, Madam Majority Leader, please.
Thank you, Mr. Chair. I think that with that, what might be the best course of action, and I think Mr. Willick has joined us down in Las Vegas, and I also have Ms. Pollock available by Zoom. Obviously, as you can see, when Min reached out to me, I was happy to help work on a piece of legislation. As I mentioned, several states have enacted either for full versions of Caden's Law or portions of it. This bill is portions of it that we thought might be appropriate. I know that there is probably going to be quite a bit of discourse on this particular policy, and so I'm grateful for the hearing today. And obviously, I think as everyone on this committee knows, when you get into custody disputes, that is always a difficult place to be. However, I do think that there should be protections to prevent some serious missteps as are present in this particular case. And so with that, Mr. Chair, I would love to be able to take any questions that you or the committee may have and may need to call for some expert opinions from my co-presenters as well. Thank you.
Thank you. We'll start off with Senator Nguyen.
Thank you for sharing your story. Sorry, it's very emotional. I wasn't ready for that. I can't imagine what you all went through. And to see how brave you are to come in here today and share that in front of all of us is really amazing. With that being said, and this might be a question for the lawyers or the experts, I'll be honest with you, I've been a lawyer for 20 plus years and I've never heard of these reunification camps and programs. Is this something that our Nevada courts utilize, and how regularly are these utilized, and what kind of regulations and process do they have to go through? I'm utterly shocked that we have these kinds of programs.
So thank you for the question, Senator Nguyen. Nicole Canizaro, Senate District 6, through you, Mr. Vice Chair, to Senator Nguyen.
Please do go direct.
Thank you. I do think that that is a very good question, and I think that what you will hear is that while we don't necessarily have these reunification camp situations in Nevada, there is reunification therapy that is typically used by the courts. For more perspective on that, I think I would ask for Mr. Willick to weigh in, because he does practice in this area. And so I think, one of the things that we are trying to prevent is from having something like that be a forced mechanism in some of these cases. And so I'll leave it at that, and if Mr. Willick has anything else to add.
I just want to make sure that, please proceed. We can hear you now.
Okay. I'll gladly answer any questions. To the best of my knowledge, there are some therapists who utilize this matter, but there are no institutions practicing it here yet.
And if I could just have you state your name for the record, please.
Sorry, I did that, I guess, when the mic was dead. Marshall Willick, Marshall Willick.
And thank you for joining us. We do have a couple of follow-up questions for you, sir. Senator Nguyen, please.
I'm glad to hear that we don't have like these kind of circumstances, but it sounds like we still have this type of, I guess, therapeutic type intervention, if we can call it that. Do our courts currently utilize this type of therapy and order this type of therapy in the family courts?
Marshall Willick, for the record. Yes, some judges are doing so. The people in front of you, the judge was removed from the case and was reassigned elsewhere because the judge had already made up her mind what the facts were before hearing any testimony. But she sent these people to one of these camps in New York at the request of opposing counsel.
And so this was a district court judge. This wasn't a hearing master?
Family court, Marshall Willick, family court judge.
So even though we don't have them operating in the state of Nevada, this Nevada judge ordered this family to this program, I'm going to use that term loosely, in New York.
Yes, Senator. Marshall Willick again. There are organizations that follow these, and I can explain, I was going to explain how this works in my testimony in chief, but there are some of these programs in California. I think there's at least one in New Mexico, and there are a couple in New York.
Do you know if any other Nevada judges have ordered or forced families to go into these programs in California, New Mexico, New York, where they currently exist?
Marshall Willick, for the record. Yes, I've practiced family law here for over 40 years. I'm a certified specialist and an AAML fellow. I've litigated about a dozen cases involving immersion therapy at trial and on appeal, and I've looked into the programs quite closely.
Have any of them, do any of them have any good outcomes, or do we have just terrible horror stories about these programs from other cases that you've litigated?
Marshall Willick, I've never seen a positive outcome in any of the cases that I have followed. If I can just sort of expound on how it works.
I think that would be helpful if that's okay, Vice Chair.
Please proceed.
Thank you, Marshall Willick. It's called immersion therapy. The core of the bill before you is Section 5, which seeks to ban that practice, which I find particularly pernicious, through which an estranged parent seeks to break a child's will and spirit. It involves isolating the child from any emotional or other support systems and leaving the child in a hostile environment until the child parrots back a prepared script saying how wonderful the estranged parent is. In short, it's programmatic brainwashing intended specifically to cause Stockholm Syndrome in children. And in my experience, it screws kids up for life. The program comes from the work of a quack out of California named Childress. It has not been peer reviewed or approved by the American Psychological Association or anyone else reputable. It's pseudo junk science, almost always destructive to children's health, welfare, and future. The places applying this therapy have been investigated by various states and other institutions, and they've been sued for child abuse. I wrote a legal note on that practice about 8 years ago after a different case involving different parties, but the same practices. I put it into the record for background information. In that case, a perfectly healthy and happy child was rendered physically and mentally ill for years. We don't let prisons do to inmates what is being done to these children. It basically amounts to torture, and it should be banned. Some parts of the bill as presented might need amendment, but I think others are addressing those sections. For my part, I have about a half a dozen personal cases that I've litigated, and I've seen what's happened to the kids. I could give you example after example of the outcomes, but that's common, that what happens in these cases. I've seen a lot of runaways, leaving the children involved being open to being preyed on the streets. In another case from that same judge, a 15-year-old was turned over to a parent who she said sexually molested her. I don't know anything about the truth of the underlying facts, but that's what the child said. The child ran away and disappeared for over 2 years, resurfacing on her 18th birthday with the statement in public that she would sue her father for harassment if he ever attempted contact. But what would have been her late adolescence and her education were pretty thoroughly trashed, and her future has been greatly endangered through a casual handover of a child to a parent who the child claimed was abusive. I'm not saying that all therapy is inappropriate. I'm just saying that this particular practice of immersion therapy and turning a child over to the sole custody of someone claiming to be abusive is problematic, and it shouldn't happen. I'll gladly answer any questions about the therapy, the programs, the camps. As I said, I've investigated all of it fairly closely.
And Mr. Vice Chair, Nicole Canizaro, Senate District 6. I think through you, and also partially in response to Senator Wynn's questions, I wanted to note one thing and then offer that Ms. Pollock might also be able to provide any. I didn't want to cut her off from being able to provide any responses to that as well. The one thing I would note in the bill is that we have sought to put into the language of this Senate bill a definition of what would be considered reunification treatment. And then within Section 5 of the bill, you will note that there are parameters around when a court could order reunification treatment. Some of those parameters include that the court cannot do that, can issue an order to require a child to receive reunification treatment unless there are generally accepted and scientifically valid proof demonstrates that the treatment is safe, effective, and of therapeutic value and will not harm a child, and that it's not predicated solely on isolating that child from a parent that otherwise they may be bonded to. And so what we've tried to do, in recognition that there are some reunification therapies, but obviously we have an example here today, and examples potentially of other types of treatment that may be wholly inappropriate. And so that's what we're trying to, I think, restrict with the language of this bill, is to recognize that there are some things that may be useful when we're talking about child custody matters, and there may be instances where that is appropriate. But if we're going to order a child to be part of some sort of therapy, that there should be parameters around that. And so that's what Section 5 of the bill is seeking to do, and in there you will also find that definition of what we've put together for reunification treatment, because I do think that there are grossly negligent and very harmful practices. We are trying to alleviate those and still give some tools for when families may need some therapies, which I think is maybe some of the concerns you will hear today as well. But with that, Mr. Vice Chair, if Ms. Pollock has anything else that she may wish to add.
Thank you. I'm happy to provide additional comment. For the record, I'm Danielle Pollock. I'm the policy manager at the National Family Violence Law Center at GW Law. We provided technical assistance and guidance to Congress for the development of this law, which was, as noted, it's part of the Violence Against Women Act that was reauthorized in 2022, and several states, including your neighboring states, have adopted it. The provisions in part or entirety, including California, Colorado, Utah, Arizona, New Hampshire, Pennsylvania, and several others. And so if you do adopt these provisions, you are in step with sort of the way that policy is moving to create more protective measures for children in these contested custody cases. It's important to understand also that it's developed to kind of target these kinds of cases where there are abuse allegations, and then where there are cross claims of these alienation like concepts which are not scientifically supported. And what happens in these cases are a few things which Congress sent to states as guidance to say, this is how you can fix this problem, because they unfold in very similar patterns across states, across districts, across counties. And so the training is really focused on trying to get the courts to better recognize and understand what abuse looks like, what perpetrator and victim behaviors are, what course of control is, and how it manifests in these families, so that they can better identify when they are looking at evidence that's brought before them. And then it requires that they look at all past evidence of abuse, because we know, it's an indicator of the likelihood of a person perpetrating further abuse, and also requires them to look at the intersection of intimate partner violence, so adult on adult violence, and child abuse, because those also co-occur at higher rates when one or the other is present. And then very importantly is the expert section, because many times you have in these cases folks who are testifying as experts who are really just not appropriately qualified. They don't have substantial experience working directly with survivors of family violence. They're primarily forensic folks. And in those cases, they are all paid experts. And many times a parent who's accused of abusing will hire one of these experts, and they will come and provide testimony or evidence to the court and really sort of mislead them in many cases, get them to minimize the abuse evidence or to discredit it, and to buy into these pseudoscientific concepts like alienation. And then they will oftentimes make a recommendation for the remedy, which is reunification. So alienation, in a nutshell, is the idea that a child is not actually abused or at risk or at harm, but that they've been brainwashed by the parent that they want to stay with. And it's not, recognized in a diagnostic manual. It's not anything that any medical association recognizes, and yet courts are making these determinations over and over in courtrooms around the country that, in fact, they think that the abuse didn't happen. They don't believe the parent who is the protective parent and the children's disclosures of abuse, and instead they buy into these concepts that the child is actually just, being brainwashed to believe they were abused. And then the remedy to that is to go to these sort of extreme reunification treatments, which are also not supported scientifically. They don't follow normal protocols of therapeutic care. And some of them, the most extreme ones, are like from Min's family that you heard about today. The children are sent out of state to these sort of intensive camps or treatments, and they're entirely cut off from their safe protective parent who they're bonded with. And so the bill works to restrict courts from doing that. In the less extreme, although still very traumatizing and problematic for children, many times they're ordered into reunification treatments, like in office, in some, in a local place. And that can also be very, very difficult for children who've been abused to be in the same room with the person who's abused them and being sort of coached or told, you have to play with this person. If you don't, you won't be able to see the parent you prefer, the parent you want to stay with, the parent you say is safe. So there's a very problematic practice, unfortunately. And that's why Congress recognized that this problem is happening in state courts everywhere. And part of the reason it's happening is because it's incentivized. This is private custody we're talking about. So it's not, the state is not a party. It's one parent versus the other litigating over custody. And so everything is self-pay, both, all the attorneys, the experts, the guardians ad litem, the custody evaluators. So there is a profit element to this also.
And thank you for joining us and providing us some context so that we all have a better understanding of exactly what's happening. We'll go next to additional questions from the committee. Members, any additional questions? Senator Krasner, please.
Thank you, Chair. Thank you, Chair. Thank you, Senator Cannizzaro, for bringing the bill. Thank you for being so brave to tell your story, and I'm very sorry for your loss. Senator Cannizzaro, I appreciate that you're trying to restrict this reunification therapy, but can't we just get rid of it completely? It sounds terrible. Thank you.
Thank you for that, Senator Krasner. Nicole Cannizzaro, Senate District 6. So I think one of the things that, in sort of talking with some of the practitioners in this area, is that there may be times where reunification therapy that is, that is not what we're talking about with these reunification camps, where there are claims of alienation that are not scientifically supported, where these therapies that are being utilized in some of those situations can be extraordinarily detrimental to the children, that there are legitimate purposes for some reunification therapy, where you may have parents, one of the examples that was offered to me, and I'm sure you'll probably hear at some point today, was you may have a parent who has been deployed for a period of time, right? And so because that child is now coming into contact with someone who they have not seen for a very long time, reunification therapy can provide some good structure to allow for that bonding to occur and for that relationship to develop, where you don't have a parent who was abusive, right? We're not talking about a situation where there are allegations of child abuse or domestic violence, and so what you're looking at is how can we help make sure that there are still opportunities for a child to bond with a parent where there might not be these same sorts of allegations, or you're not necessarily trying to protect the child, but you're trying to help make sure that those family relationships stay in place. And that's why I think in the bill there is language that does not completely ban reunification therapy, but that we recognize that this is something that can be utilized in an abusive fashion. And so what we want to be able to do is to say there's an appropriate place for this to happen, but it should be scientifically and evidence-based. It should be something that is not going to be harmful to the child, and we should not be peddling in some of these alternative theories of isolation or alienation such that we're pitting children against parents to whom they are bonded, and especially in cases where there are allegations of domestic abuse or child abuse. And so I think that you will probably hear from some practitioners that there are some legitimate uses of certain types of reunification therapies, and so an outright ban I think would be more detrimental, but we definitely are trying to make sure that what we are putting in place here is not having the effects of what ultimately occurred in Min's case.
Members, any additional comments or questions? Seeing none, Senator Nguyen, please.
And this might be for the lawyer. Currently, when you're talking about child custody issues and there are allegations of domestic abuse, do those allegations of domestic abuse or an arrest on a domestic violence like charge, are they considered in all cases, or do you have to have a conviction?
Marshall Willig for the record. The standard of evidence is essentially preponderance for most of the statutes. It's clear and convincing in other contexts, but no, you don't need a conviction of a domestic violence charge in order to bring it up in the civil context in a family court case.
And so the language in here about how you don't have to have, I guess, you currently don't need a conviction. It's a lower standard than you would in a criminal proceeding. I just want to make sure that there isn't anything different here than what is normally occurring.
Marshall Willig for the record. I wasn't focused on that piece of the bill. I was really looking at the ban on emergent therapy. But I don't believe there's anything in this bill which changes the legal standard of evidence that's required in a family court proceeding. It's still a civil proceeding. And therefore, we're either at preponderance or clear and convincing, depending on the test.
Thank you. I just wanted to clarify that. I was pretty sure that was the answer, but I wanted to make sure.
And Nicole Cannizzaro, Senate District 6, impartially in answer to your question, Senator Nguyen, if I may, in section 6, where it talks about in making findings relating to allegations of domestic violence or child abuse, it does allow for the court to consider all relevant and admissible evidence of past domestic violence or child abuse, including without limitation evidence of arrests for domestic violence or convictions, right? And I think that there's obviously weight that will be given via evidentiary standards of whether it is an arrest and an allegation, whether or not it is a conviction. If it's a conviction, obviously it's been proven by beyond a reasonable doubt, and so we're not talking about clear and convincing or preponderance of the evidence, but here there are some parameters that do allow for that, for any admissible evidence in those regards to come into play.
Thank you. I just wanted to make sure. I know that sometimes obtaining convictions in these kind of cases is very difficult, and sometimes it is further traumatizing for victims of domestic violence to follow through with some of those cases, and so oftentimes they get dropped, but it doesn't mean that it didn't happen. So I just wanted to make sure that in circumstances like that, where maybe there isn't a conviction, but there is a way for people to present evidence of ongoing abuse, were considered. So thank you.
Remember, any additional comments or questions? I'm sure that there may be some in case folk will be testifying in opposition. We can flesh some of those out. With that, we'll go ahead and invite both of you to please sit back in the gallery. And at this time, we'd like to open it up and invite those wishing to testify in support of Senate Bill 275. If you could please come forward in Carson City or Las Vegas. I do see some folk in Las Vegas. We'll go ahead and start there, and then we'll move back to Carson City. I do want to remind everybody, if we could please limit your remarks to 2 minutes whenever you're ready in Las Vegas.
Thank you, Vice Chair Flores. Liz Ortenberger, Lizortenburger, and I'm the CEO for Safe Nest. And I just want to share some statistics with you. First of all, it sounds to me that these young people went away to recidivism camp in 2022, and we should all be incredibly grateful that they are alive. One thing that we heard in their testimony was strangulation. Victims that are strangled by their abuser have a 750% higher chance of being murdered. That is also directly correlated to cop killers and mass shooters. For our justice system, either CPS or the judge or hearing master involved, to not understand that simple fact is a complete dereliction of duty. People ask me all the time, how can we end the epidemic of domestic and sexual violence? Particularly in Nevada, we are the #2 most domestic violence homicides in the country. Clark County, however, is the most dangerous county in the country for domestic violence homicides, and Las Vegas is the most dangerous city. It starts with the children. Protecting our children from further abuse and robbing that custodial parent from that protection is how the cycle of domestic violence continues. SafeNest sees this regularly in our court system. Everything in this bill, the training, the experts, and the entirety of the legislation can help make Nevada safer for the next generation. I will also add, as I'm sure you are about to get bombarded with folks who do not appreciate this bill, false reporting in domestic violence, the research shows, is between 2 and 8%. Yet it is often a reason that public defenders and others doing their jobs cite that we are rampant with false reports. The data and the research does not hold that out. Thank you.
And thank you for joining us. Is there anybody else in Las Vegas wishing to testify in support? Seeing none, at this time, in Las Vegas. We'll get some more folk here in Carson City. We'll move back to Carson City. Whoever wishes to go first.
Hello and good afternoon, Vice Chair Flores and members of the Senate Judiciary Committee. My name is Beth Smith, BETHSMITH, and I am here today in support of SB 275. SB 275 is a victim-centered and trauma-informed approach to handling child custody agreements when there is a history of abuse or violence. Senate Majority Leader Canizzaro's proposed legislation provides protections for children in custody and visitation cases involving domestic violence. It sets standards for expert testimony and ensures our courts receive training to make more informed, responsible decisions. Our state has the second highest domestic abuse rates in the nation, with more than 40% of Nevada's women and 30% of Nevada's men experiencing domestic violence in their lifetime. And that's only the abuse that is known. Domestic violence flourishes in secrecy, with victims often feeling trapped by fear, shame, and extreme control by their abusers. I know this truth because I am a survivor of domestic violence from a prior relationship, and today is my first time ever sharing this publicly. My son and I recently went through an extremely traumatic custody case involving domestic violence, and I intimately understand the positive impact SB 275 will have through my own lived experience. Senator Canizaro's bill places child safety and well-being above all else when making decisions about visitation and custody, especially in cases where domestic violence is present. When a victim shares a child with their abuser, the abuse can last long after they leave that relationship, and they often fear for the safety and well-being of their child because they may become the target of mistreatment. This is true for me too. SB 275 requires judges to consider the history of abuse or violence when determining custody and visitation. Senate Bill 275 strengthens our support of domestic violence survivors and helps ensure family court has the tools it needs to serve them in the best way. Please join me in supporting this legislation, and I thank you for your time and consideration. Thank you.
And thank you for joining us. Please, next speaker in support.
Good afternoon, Vice Chair and Committee. Serena Evans for the record, SERENAEVANS, and I'm the Policy Director for the Nevada Coalition to End Domestic and Sexual Violence. I first want to start off by thanking Min and each of her brave children, as well as Beth, for bravely sharing their stories with us today. Senate Bill 275 is a victim-centered bill that ensures child safety is prioritized above all else in custody decisions involving domestic and familial violence. As the state Senate Majority Leader said, these provisions outlined in SB 275, also known as Caden's Law, were included in the 2022 reauthorization of the Violence Against Women Act and are not new ideas, but are established best practices to keep children and families safe. It is critical that courts carefully weigh the potential risks to a child when making custody and visitation determinations, including clear language in state statute that permits courts to consider these risks and consult with qualified experts will have a meaningful and positive impact on the safety and well-being of children. We know that these hearings and negotiations are complex and rarely present as black and white. However, this bill will provide courts with better tools to make informed, safety-focused decisions, keeping the best interests of the child at the forefront. We urge its passage. Thank you.
And thank you for joining us. Good afternoon. Welcome.
Thank you. Good afternoon, Vice Chair Flores and members of the committee. For the record, my name is Kristen Kennedy, KristenKennedy. I'm the Executive Director for the Domestic Violence Resource Center in Reno. Our organization supports SB 275, which requires that courts consider evidence of a parent's history of violence or abuse when making custody determinations. We also support the bill's provision mandating that judges who preside over such proceedings complete domestic violence and child abuse training. I'd like to address an important issue that may not be immediately apparent to those who haven't experienced domestic violence firsthand, but it is all too common, and we see it at our organization very frequently. Abusers frequently use children in custody battles as tools to continue their manipulation, intimidation, and control of victim survivors. SB 275 attempts to shift the responsibility of child reunification with an abusive parent to the perpetrator and away from the victim survivor, who is often held responsible for enforcing child contact with an abusive parent. We see that as a positive step toward abusers taking responsibility for their actions and controlling their own behavior rather than exerting power over others. But most importantly, we support SB 275 because it prioritizes the rights and safety of children above all else. So thank you for your time and the opportunity to speak to you today.
And thank you for joining us. Good afternoon. Welcome. And sir, I believe your microphone may not be on.
Is this on? Okay.
There we go.
Hello, my name is Cody Walker. I'm grateful to submit a brief statement regarding the experiences that my 3 children and I have been caught in over the past 4 years due to the very issues outlined in SB 275 and testify in full support of this bill. My former spouse had been mentally unstable and emotionally abusive throughout our marriage. 50-50 custody was initially entered into our divorce case. She and her new husband inflicted severe emotional and psychological abuse on our children. Over time, this escalated to physical abuse until her new husband was even arrested for the strangulation and abuse of all 3 of my children and in the presence of their mother. My son was picked up by the neck and thrown onto the floor. Regardless of the astounding amounts of evidence in our case, many recordings of the abuse, including photographs of injuries, multiple doctor reports with clear signs of strangulation, the evidence went unseen by the court. The judge granted our request that the kids could attend counseling to help with the abuse. Mom was granted the choice of counselor. Despite reunification therapy not being officially ordered, she was able to choose a therapist from a coalition for reunification therapy. This therapist that she chose is now being reprimanded and suspended and disciplined by the Nevada Board of Marriage and Family Therapists. This therapist was vetoed by my counsel. The second reunification therapist that Mom chose announced she was performing reunification therapy rather than the ordered counseling for the kids. Against my objection, this therapist received approval by the court clerk. When the results of reunification therapy were first finding Mom with serious mental health issues, and the children were going to be limited to supervised visitation with her. At that point, this same therapist that's now being disciplined was then hired as a divorce coach by Mom, under the guise that she was her personal therapist at the urging of the reunification therapist now working with our children. At this point, the false parental alienation claims began, and all reports were suddenly flipped 180 degrees, with Mom being fine and now Dad bad. When questioned, our reunification therapist stated that she got a second opinion. I was not given due process and was ordered to see a therapist to be fixed of my parental alienation. After 3 letters from 3 different therapists confirming that I was a very fit parent and should be allowed contact with my kids, and they were troubled of what was happening, I was finally allowed to then have the children to be interviewed after 4 years of being denied interviews. Only I was ordered to have those interviews performed by someone that is costly, more than I can afford. Because of the cascade of events that began when reunification therapy was introduced a year and a half ago, I lost 99% of custody of my children, and for over 6 months I had not been able to see my children at all. Meanwhile, the man who was arrested for strangling them and is abusing them to this day lives in the same home as my children and has free access to my children. While the judge is using the loophole of temporary orders so as not to hold a trial and have to see evidence. My case is the perfect example of what happens when we don't have Section 5 of SB 275 as part of our law. Co-parenting and child custody is not a zero-sum game. Especially when it comes to allegations of abuse, you cannot improve the relationship between one parent and a child that has been disrupted by removing or taking away from the quality of the relationship with the other parent and the child. The notion that we should harm one parent-child relationship to improve the other is cruel and in direct opposition to the best interest of any child. As outlined in Section 5, if there is a strong bond of support and nurturing love with the child and that parent, why would that be removed when that parent has never been accused of criminal behavior or harming the child in any way? My children have lost their relationships, their school, their freedom of choice to attend their lifelong religion, their straight A records and honor status in school, their physical health, their emotional well-being, their innocence, and most of all, their sense of safety. They've lost all faith in a system that should have been supporting them, and despite running away on 5 different occasions, they have repeatedly been placed back in the home of their abusers. As I have dedicated all that I have and all that I can to undoing these wrongs, exhausting every financial path that I could, I have experienced the loss of all my finances. This, coupled with the fraudulent income figures submitted, led to support orders that I absolutely could not afford. When this fact was proven, the judge stated, "Oh, he will find a way." In reality, it put me on a fast track to financial ruin. I have lost my home and my career, and my credit has been destroyed. It has obliterated the ability to rebuild, and at this point, even gathering funding needed to provide testimonies of my children has become bleak. My children, who bravely spoke out many times with the hope of rescue, are having their health and safety dwindle by the day. We are caught in a situation of utmost despair, with no way forward without massive financial profit to provide the children with one last attempt at having their voices heard. My children sit awaiting justice until somehow I win the lottery to afford their justice. I believe that anyone against this bill are mostly attorneys hoping to profit from it, who have built careers. As I've consulted with attorneys who have told me most of their cases, they utilize parental alienation, regardless of what's happening, because it works. The therapist, when I questioned her how reunification therapy works, even though I had done much research, we have subpoenaed recordings of her stating that it is a very rare and very specialized, and there's only about 5 in all of Nevada that perform this special therapy. And then she went on to explain how it provides no therapeutic purpose. It's only a legal tool used by the courts. For 4 years, my children, fortunately, have not been sent to a reunification camp. Now that they are being disapproved and frowned upon, new strategies are being utilized. My daughter, my oldest, was sent to a mental health behavioral hospital to be drugged, to silence her, and to discredit her testimony. This reunification therapy is extremely abusive and allows these few ladies that are in a coalition together to carte blanche, have access to the children, and do whatever it takes to help the relationship with the parent that retained them. I am here to testify that SB 275 should be passed and give my full support and approval of this bill. Thank you for your time.
Thank you for joining us. Please, whenever you're ready. And it's on the desk itself.
Good afternoon. My name is Brittany Dangerfield. I'm here to submit a statement in support of this bill. My siblings and I, like many here today, have been victims of wrongful parental alienation claims that led to the court handing custody of us to our abuser, followed by court-ordered reunification therapy. My father abused me physically, emotionally, psychologically, and sexually from the time I was an infant until I was 18 years old. When I attempted to use proper channels, such as my guardian ad litem, I was yelled at and told I was lying. I lost complete faith in the system, as my mother's attempts to report abuse were eventually stricken due to parental alienation claims and technicalities. After I completely aged out of the system, I opened a case to bring all of my siblings and my testimony to a judge once and for all. When the court pushed back the hearing date, recommending they go back to our abuser, my sisters felt the system had failed them entirely. At this point, they felt that they had to run away. When they were picked up by law enforcement, they were thrown into a juvenile detention center for months and treated as criminals. One of our greatest injuries occurred when my sisters were ordered by the court to participate in an out-of-state reunification program. In the middle of the night, they were taken from the juvenile prison, chained in handcuffs, and roughly thrown into an unmarked white van by 2 large men to be handed back to our abuser. This program required my sisters to be isolated and forced under great duress into cruel, inhumane, and degrading treatments and punishments. My mother and I did not see them until they aged out of the system. We have all been trying to grapple with the devastation and loss since. Specific provisions of SB 275 can provide protections afforded to children and to parents such as our mother, with whom we bonded through nurturing love and protection. In addition, SB 275 could prevent the court from ordering a child into reunification without proper awareness and training of domestic abuse. Programs like the one my sisters were subjected to have been repeatedly rejected by professional communities, and had our abuse testimonies been taken into consideration, decades of suffering could have been avoided. Based on our experiences, I'm here to testify that the proposed legislation would have protected us then and others now from serious harm, and I'm in full support. Thank you.
And thank you for joining us. Is there anybody else wishing to come forward in support of Senate Bill 275, Carson City or Las Vegas? Seeing none, BPS will go to the phone line to those wishing to testify in support.
Thank you, Vice Chair. If you would like to offer testimony in support of SB 275, please press *9 to take your place in the queue.
Hi, good afternoon.
Hi, good afternoon. Please proceed.
Yes, my name is Beatrice Saldivar. I'm from Austin, Texas. I would like to offer my support for the S Bill 275. I'm sorry, I'm very emotional here. My daughter was taken away to reunification camp. I was falsely accused of parental alienation. When my daughter reported sexual abuse that her father, for 2.5 years, had been getting in her bed all night and sexually touching her. He got therapists and lawyers to flip the sexual abuse to parental alienation. The local therapist, Amy Eichler of Georgetown, Texas, wanted to spend the money, and she went ahead in her business, gave more money. She wrote a false report, falsely accusing me. They went with transporters to my daughter's home. They took my daughter to New York to Linda Gottlieb. Linda Gottlieb tried to force me to write a false letter, which is their golden multi-million-dollar nugget to get my daughter back. I refused to write the letter that she wanted. They call it apology letter. Since then, I haven't been with my daughter since December 10, 2021. I did everything they told me. I could never get my daughter. I have spent over $1 million, money that I didn't have. I had to put my mother's home in a home equity loan. They destroyed my family. They destroyed my daughter. I'm still without my daughter. They told my daughter that her mother was evil and her father was God. Well, my daughter was with Linda Gottlieb in New York City. The subpoena records we got from Linda Gottlieb and Amy Eichler, they said the child is not smiling, sitting next to the father. So they said, don't worry, we're going to create smiles out of the videos, which are fake photos. This is a fraud industry that has destroyed my mother, my father, all the maternal family. So my daughter's grandfather died, my father, without being able to reunify with his youngest granddaughter. My mother is in bad health. I have spent over $1 million, money that I did not have, and I work 2 jobs now to try to pay it back. I went to a final trial where, unfortunately, some judges are not very educated about this. They follow only whatever the gossip, the misstatements of therapists that this is and lawyers that want to profit from this industry. After 2 weeks, the guardian ad litem, Stephen Gonzalez of Travis County DRO, he told the jurors that my daughter got endometriosis from her mother, that I was dangerous. First of all, that is scientifically incorrect. Second of all, my daughter didn't have endometriosis. They would do everything with mislead and would lie. I still don't have my daughter. It's 1,570 days without my daughter. I'm asking you respectfully to stop any children ever from going through any reunification camps. They're very dangerous, and they have destroyed us for a lifetime. I'm still without my daughter, and she is my only daughter. And I can never gain that time back. My daughter is going to graduate from high school in just a couple of months, but I'm still without her. So please support this bill in reunification camps forever. Thank you.
And ma'am, before you hang up, can you please repeat your name and spell it for the record?
Yes, my name is Beatrice Saldivar, and I'm from Austin, Texas.
And can you spell that for us, please?
Yeah. Yes, Beatriz, and the last name is Saldivar.
Thank you again for joining us. Next caller in support of Senate Bill.
Thank you.
Thank you. BPS, next caller in support of Senate Bill 275, please.
Hello, my name is Trisha Singer-Romar. I am from the state of Ohio, and it is spelled TRICIA. Singer, SINGER hyphen ROMOHR. As much as I would like to tell my story, I unfortunately had to agree to give up my right to free speech, my First Amendment, to get my sons back in my life after experiencing much of what you have heard today. So all I can say is I am in absolute and total support and beg that you please protect the children of Nevada with Senate Bill 275. Thank you.
And thank you for joining us. Next caller in support, please.
Hello?
Yes, we can hear you. Please proceed.
Hi, my name is Jennifer Garling, and I am in support of the bill. I am currently outside of Houston, Texas, and I have a wonderful family friend that is going through the situation. And there has been great evidence supporting everything that's happening to his children, and he cannot get it through to the court system. The kids have no voice, and this has been going on for close to three and a half years now, and I've seen the family just completely deteriorate, and I feel so much pain for those children. And it's opened my eyes to looking in my own area and kind of trying to figure out how I can help these poor children. I never knew that this existed in the United States of America, and I 100,000% support this bill.
Thank you for joining us. Next caller in support, please.
There are no further callers to provide support testimony at this time.
Thank you. At this time, I'd like to invite those wishing to testify in opposition to Senate Bill 275. If you could please come forward, Carson City or Las Vegas. I see that we have two folk in Las Vegas. We'll go ahead and take care of those, and then we'll come back to Carson City. Whoever wishes to go first in Las Vegas. Oh, and by the way, just for the sake of clarity, based on my timing, 4 callers went over the 2-minute limit. Out of respect and to be transparent, we will allow for 4 members in opposition to go over 2 minutes. Please proceed. In Las Vegas, whoever wishes to go first.
Good afternoon, Chair, members of the committee. My name is Cody Gamble, CODYGAMBLE for the record, and I'm testifying in opposition. First, I'd like to express my sympathies to the abused. Your experiences are absolutely horrific. I'm a father of 4, a fire department engineer, and a soon-to-retire Black Hawk pilot in the Nevada Army National Guard. I'm here because I've lived how false abuse allegations and parental alienation are used to dismantle a parent-child bond. A false accusation forced me to resign my commission and to defend myself alone in family court. CPS ultimately unsubstantiated the claims, but that didn't stop the other parent from using them to begin the slow, deliberate process of alienation, which is essentially a grooming process, and it's happening right now to my kids. SB 275, as written, could be used to reward that behavior. It gives power to allegations alone, and it ignores how often they're weaponized to erase a parent. My case, luckily, drew public attention. It produced the Nesser decision, which backed transparency in family court, and there's a separate pending matter in the Nevada Supreme Court that challenges the type of secrecy that allows this misconduct to go unchecked. Now, I've provided a proposed amendment, even though I'm not a lobbyist, and a scientific meta-analysis, which is the gold standard in the scientific community as far as I understand it, that's consistent with PA and that's all been submitted to the addressing my concerns to the committee email. So in conclusion, I don't oppose the intent behind SB 275 at all. In fact, I underscore it. I just oppose the proposed execution of it and the language. SB 275 must be amended, in my opinion, to require courts to distinguish between proven abuse from alienation and to train judges to see the difference. Otherwise, this bill will make it easier to destroy families in the dark. The answer is not either or, DV or PA, it's both and. Abusers must never be permitted to weaponize false claims of alienation and use it as a shield to escape accountability. And similarly, alienators should never be allowed to wield deceitful allegations as a strategy or a sword to manipulate and harm the psychology of the kids under false pretenses. I have no further comment.
Thank you for joining us. Next speaker in opposition, Las Vegas, please.
Vice Chair Flores and members of the Senate Judiciary Committee, my name is Shelley Cooley. I have been a family law attorney in Las Vegas, Nevada for more than 20 years, and I'm an unpaid lobbyist on behalf of Nevada Justice Association. And I want to thank the folks that have testified in support of this bill, specifically the folks who have had intimate experience with domestic violence and child abuse. I'm so sorry that these have been your experiences. I have specific limited opposition to SB 275 that I would like to address briefly. My colleagues in Carson are going to address Section 5, and I would like to address Sections 6 and 7. And I would like to start by saying, as a family law practitioner, children should absolutely be protected from domestic violence and child abuse. It's in our statutory scheme, and the best interests of children are of paramount concern when family court judges are making child custody decisions. With regard to the issues, Section 6A is problematic as written. In family law, we have a shortage of mental health professionals who are willing to provide treatment for children going through litigation. And we have even fewer mental health professionals who are willing to testify and or perform child custody evaluations. Section 6A refers to expert evidence. What does that mean? What is a professional who possesses demonstrated expertise and substantial clinical experience that are not primarily of a forensic nature? Section 6.3c defines forensic as provided pursuant to a court order for the purpose of litigation, including child custody evaluations. So based on this language, we will need a child custody evaluator as well as a domestic violence expert. So we'll have two different experts needed for this type of case. In Las Vegas, Nevada, I'm not sure up north, but a child custody evaluation costs approximately $15,000 or more, depending on the allegations that are raised. And then we'll also need a domestic violence expert. Who qualifies for that? I am not actually aware of who on our list of folks who are evaluators or therapists would actually qualify as domestic violence experts. Section 6B is acceptable as written, and Section 6C is concerning as it prevents a court from ordering reunification therapy to folks who have been alleged to have committed domestic violence rather than found to have engaged in an act of domestic violence or child abuse. If this language were to be revised to having been found to have engaged in an act of domestic violence or child abuse, then we would ensure that judges are making decisions based upon the facts that are before them. And we would also ensure that children were protected. And we would also ensure that, quote, bad actors were not able to advance their agenda in the family court system when there's no basis to their allegations. In family law, unfortunately, we do see false allegations of domestic violence or child abuse that are made for strategy purposes. It's more common than I would like to admit, but we do see that sort of thing happen. And I think that it's really important that we have protections in place that protect all folks, with children being of paramount importance. And we want to make sure that whatever laws that we have in place don't embolden parents who are gatekeepers or who are abusing their children. So like the speaker who spoke before me said, this isn't an all or nothing situation. There needs to be a middle road, and changing from alleged to have been found to have engaged in. It's consistent with our best interest factors that judges and practitioners have to follow. It'll also help protect parents as well as children. Section 7 is overly broad. We had speakers in support of this bill testify that it required judges and other court professionals who are involved in this case to be required to participate in domestic violence and child abuse training. But the specific language in this statute requires anyone, any person who may have regular and routine contact with persons who are involved in a child custody proceeding to take specialized continuing legal education or legal education courses on domestic violence and child abuse. As a family law attorney, I have to take at least, I believe it's 12 hours of CLE credit each and every year. And during the course of my credit, we get training in child abuse and domestic violence. So this is an additional requirement that I understand its concept, and I agree with its concept, but it is overly broad as written. And if we were to remove the section on that I just stated, then I think that section 7 would also be acceptable. So thank you for allowing me to testify. If you have any questions, I would be happy to answer them.
I think we do have a couple. Thank you for joining us. Senator Nguyen, please.
I have a question, just because we heard kind of conflicting information from one of the previous attorneys that spoke during the presentation of the bill. When I asked some questions about what the existing law was on the admissibility of allegations of sexual and domestic violence, and they had indicated that, you know, there's obviously a different standard when it comes to family law proceedings, and that currently the way the law exists is that evidence without a conviction is still potentially admissible. Obviously, the standard is different in family court proceedings. And what I'm hearing from you is that you're hoping that there's more certainty in convictions in changes to the way this bill is presented. So I'm curious, are you asking for an overall change in the way the family courts are currently assessing this domestic violence allegations now?
Shelley Cooley for the record, my apologies. No, I think that what Mr. Willick testified to is in fact correct. We do have a lower standard in family court cases with regard to allegations of domestic violence and abuse. My concern with this bill is in section 6(2)C. It specifically states the court shall not issue an order to remediate the resistance of a child to have contact with a parent alleged to have committed domestic violence or child abuse unless the order, and it goes on to specifics. The way that we think that needs to be changed is from alleged to have committed should be changed to who has been found to have engaged in an act of domestic violence or child abuse. And the reason is that we want to make sure that that these aren't baseless allegations, that there is some that these allegations have actually been found to have occurred. So not allegations, but child abuse or domestic violence has occurred. And that would be, a judge would have to review photographs of evidence or hear testimony, but the judge would be the decider of that information, but that information would be based on evidence before it, instead of just going into court and saying, Your Honor, a parent is abusive. There has to be a basis for those allegations to be made. So in order for the court to order reunification therapy or not order reunification therapy, we would need to have an actual basis of abuse or domestic violence to have occurred.
I guess I just have some concerns because it seems like you're further, I mean, to a certain extent, I feel like the courts, even with this like added language, would still have to take into consideration any of those things before making a determination. And while I'm not going to lie, knowing that there are judges in 2022, 2021, and 2025 sending children into these types of programs in our state gives me less confidence in the discretion that our judges are using on the bench. I still think that having to require an actual finding of this is going to be difficult given everything that we know about domestic abuse. I guess it's more of a comment, but thank you.
Members, any additional questions? Seeing none, thank you again for joining us in Las Vegas. We'll move to Carson City Opposition. Good afternoon, welcome.
Good afternoon. My name is John Springate, S-P-R-I-N-G-G-A-T-E. I'm a certified family specialist practicing in Reno. I've been practicing some 40 years, and I'm here on behalf of NJA. And we are technically in opposition to this bill with the understanding that some tweaks to it would be helpful and could lead to passage. We agree wholly and completely with the proponents that the sole consideration should always be the best interests of the children, and that is indeed primary to any consideration of visitation first and foremost. And it is, as a practitioner, as a person who works in our system, it is extremely difficult, as I'm sure it is for you, to listen to these horrific stories where the wheels have fully and completely come off at every level, leading to some very, very strange outcomes and difficult results for the children involved. But it is also an old saying for us, hard cases make bad law, and as we're trying to remedy some things, let's make sure that we do not go overboard here. What you have heard, of course, is what our family court judges and the judges in the rules hear on domestic matters in every case. There are allegations of alienation, whatever that means. That in itself is a very fraught concept, and there are allegations, of course, of abuse and neglect. I would like to address, if I could, right now, Senator Wynn's question on that. The standard is, as Mr. Willick said, a preponderance of the evidence, and in terms of removing someone from visitation, clear and convincing evidence, but that evidence can be sustained solely by the testimony of a person who is the subject of that abuse, of that violence. There is no requirement that there be hard evidence, that there be photographs. That is up to the judge involved. And so that person who is believable, who is credible, who can testify is enough. I think sometimes we get confused with believing that there should be police reports, and people get sidetracked trying to put in other evidence that can be eliminated for other reasons. But that one person's credible testimony is more than enough to sustain those findings, to prohibit under your statutes a finding of joint custody, to prohibit even visitation, and wisely so. Specifically, the problems with this, as written right now, is that Section 5 prohibits the court from removing a child from or restraining contact with a parent capable of providing needs for the sole purpose of improving a deficient relationship. In our opinion, this conflicts with the already existing best interest test in terms of modifying custody or visitation. It imposes an artificial bright line against removing a child for any other reason when the other parent may have caused the deficient relationship. It is without argument that there are times when a parent has caused a deficient relationship, and it may be within the purview of the child to effect some reunification time, some reunification therapy. Relationships deteriorate by virtue of the parent being absent. They deteriorate by virtue of the parent being relocated to another estate or by military service. And it is necessary at times to make an adjustment. I am concerned with restricting the court and holding its hands a little bit in terms of removing that flexibility. Granted, that type of therapy, even reunification therapy, is less usual and is not typically used very much at all. This particular immersion therapy is extraordinary and thankfully not very often. Section B is problematic in that it restricts the court in being able to evaluate the safety and efficacy of a particular type of treatment. It is, I suggest, for the court to decide and evaluate on the basis of the expertise presented to it, rather than by legislation here, precluding an entire class or method or type of treatment, particularly when we have no expert input at this point in time as to that. If, as Mr. Willick says, that immersion therapy, which is the very extreme type of treatment that we're talking about in these parties' case, is without scientific or factual basis, we should have some expertise to validate that. I believe that to be accurate, and we would like the opportunity to further work on that with you to revise some of these to provide that to the case. But that is a very extreme portion and should not be driving the rest of it here, where some limited reunification treatment or counseling can be a very effective tool. The same problem, to touch briefly on Section 6, we have in the North the same problem with regards to experts, finding people to do evaluations, finding people to do therapy, much less testify about it. And if we are restricting those people who can provide that by statute, we are binding the court's hands. The court has the ability to determine who is an expert. The court has the ability to determine whether an expert's testimony or basis is based upon validated scientific principles, and to wholly reject it if that is not the case, which may well be the situation with immersion therapy and should be. But we should not be overly restricting a very limited pool of experts that we have here. The Hallmark case remains the law in the state of Nevada as to the admission of expert testimony that is well within the court's ability to determine whether a person is an expert, whether a person can testify, and the basis of that testimony, and should remain, I would suggest, within those grounds. That's all I have on these sections. My colleague has some, unless you have some questions for me.
No questions. Thank you for joining us today.
Thank you.
And I'm sure that you'll have an opportunity to work with our majority leader offline as well. Please continue. Then thank you.
Kimberly Surratt, for the record, it's Kimberly, Kimberly, Surratt, Surratt. Here to tell you we are working with the majority leader. Everyone on this committee would expect that of me, of course. We have very good relations going right now and an expectation that some of these edits will be valuable and work out in favor of stopping these camps. If you notice, immersion camp, or the word camp, does not show up in this bill, but that is what the goal is. We need to stop it. We aren't against that. We are in favor of it, but because we would like some language changes, we of course are following the rules in opposition to this bill. But we want to be extremely clear with the committee that we are indebted to stopping this. It's bad behavior. And to answer Senator Wynn's comment about, the frequency of this, in the North, we're not seeing it. It is not frequent. And when it's put out to the listserv, you get a dramatic response from practitioners in Vegas that they are seeing a different behavior down there. I think there are a lot of tools being left on the table that are not being utilized that we need to look at. We need to look at a whole lot more domestic violence changes. We need to be looking at adopting the entire model code on domestic violence and family violence from the National Council of Juvenile and Family Court Judges. It's hard when you look at a small picture window of a change like this taken from national legislation and try to put it into our local rules and then try to make it mesh with everything else. The goal, and what you kind of hear as a complaint from the practitioners, is we're lacking resources. We're lacking resources on these cases. We don't have the professionals that we need, and sometimes, unfortunately, we are codependent on the judge making good, solid, rational decisions, and that's not always had. But it's also the system we have. That's what we have the Supreme Court for, and thank goodness we have a Supreme Court case that went that far. To show the evil that's behind this. It is evil. I'm sure I've got darts going at my back for being in opposition to the bill. The goal is not to stop it. The goal is to make it better and make it work in our system.
And thank you for joining us. If you would like to empty the seats just in case there's anybody else wishing to join us in opposition. Good afternoon, welcome, whenever you're ready.
Good afternoon, Vice Chair Flores and members of the Senate Judiciary. Paloma Guerrero, Palomaguerrero, on behalf of the Clark County Public Defender's Office. Our opposition is very specific and limited. It's about Section 6, subsection 1B. And there's been some conversation surrounding this, but one of the factors that's listed there is an arrest or convicted of domestic violence or child abuse. And I think there's a difference in being able to bring up a mere arrest as something to consider, and where it can be objected to by another party, and the judge can decide based on the arguments whether that can be admissible evidence. And what's being done here, which is putting it in statute as a factor that the court shall consider when making a very important decision about a child's custody. Arrests have absolutely no evidentiary threshold and should not be a mandated factor in determining the loss of parental rights. Domestic violence is a mandatory arrest crime, and it happens more often than we would want to that the victims are the ones that get arrested. Eliminating arrested for from the language still doesn't stop any party from bringing it up because the language still allows for any other relevant and admissible evidence.
And thank you.
Good afternoon, Vice Chair Flores, members of the committee. For the record, my name is Cadence Matijevich, Cadencematijevich, representing Washoe County. And I want to be clear, as some of the other folks who've been up here in opposition, that Washoe County absolutely is in support of the policy behind this bill. You've heard devastating stories today. And we would implore this legislature to pass legislation to avoid anyone else experiencing what you've heard today. I am here under the rules of your committee that there is a very technical change that we believe is necessary to this legislation. It is in Section 3, subsection 3. We believe it was just an oversight, but that in addition to the exclusion of delinquency proceedings conducted pursuant to Title V of NRS or a proceeding held pursuant to Chapter 432B, that we would also need to include a proceeding to terminate parental rights brought by an agency that provides child welfare services pursuant to Chapter 432B of NRS or Chapter 128 of NRS. Thank you.
And thank you. Welcome.
Good afternoon, Angela Knott from the Washoe County Public Defender's Office and the Washoe County Alternate Public Defender's Office. We echo everything that was just said. Our main concern is not the bill as a whole, but just the Section 3 and needing to clarify that there should be an exclusion under NRS 128.040 for any termination of parental rights brought by the government. Thank you.
And thank you. Anybody else wishing to testify in opposition here in Carson City or Las Vegas? Seeing none, BPS, do we have anybody wishing to join us over the phone?
Thank you, Vice Chair. If you would like to provide testimony in opposition to SB 275, please press star 9 to take your place in the queue. Caller with the last 3 digits, 176. You are unmuted on our end, and you may begin. Caller with the last 3 digits, 176. Please check that your phone is not muted on your end.
Good afternoon, members of the committee. My name is Lindsay Patton, and I am here today speaking from Reno, Nevada, to express concerns regarding SB 275. I do not represent any organization, and I, in fact, have a positive co-parenting relationship with my daughter's father. I am a concerned mother that has witnessed the detriment of parental interference due to my husband fighting for 50-50 rights in which there is no history of any form of abuse or neglect. This includes manipulative tactics that have tarnished the relationship between father and daughter. While I support the intent of this bill to prevent children from being placed in the care of abusers, I urge the committee to consider amendments to ensure that the bill does not unintentionally empower parental interference in cases where no history of abuse exists. While the measures of Section 5 are necessary in cases where abuse has been substantiated, they create a dangerous precedent when no record of abuse exists. Studies support that children who are subjected to interference or specifically alienation can cause psychological consequences. Completely restricting the court's ability to address it can cause severe and long-term harm to children and the unjust erosion of parental rights. The unfortunate reality is that interference is often used as a tool to sever a child's relationship with a fit and loving parent. By categorically removing reunification therapy as an option and preventing a child's placement with a targeted parent, even when interference is identified, the bill gives undue power to interfering parents and may ultimately harm children who are deprived of a healthy relationship with both parents. To ensure that SB 275 serves its intended purpose without unintentionally harming children or enabling unjustified interference, I respectfully request the following amendments. 1, clarify that Section 5 only apply in cases where a substantiated history of abuse exists. Courts should not be barred from addressing interference through reunification therapy or placement changes when there is no history of abuse. 2, allow the court discretion to order reunification therapy and modify custody arrangements when interference is proven and no abuse is found. Courts should retain the ability to act in a child's best interests rather than having their hands tied by a blanket restriction. And 3, recognize parental interference as a legitimate concern and ensure that SB 275 does not unintentionally enable its continuation. The bill should safeguard children from all forms of harm, including psychological manipulation by an interfering parent. I urge the committee to consider these amendments to ensure that SB 275 protects children from abuse without stripping courts of the ability to address interference when it occurs in the absence of abuse. Thank you for your time and consideration.
And thank you for joining us. Next caller in opposition, please.
Caller with the last 3 digits 489, please press *6 to unmute yourself and you may begin.
Good afternoon, members of the committee. My name is Suzanne Groneman, and I'm here today not as a lobbyist or an attorney, but as a mother who has seen firsthand the devastating effects of parental interference. I want to note that I too am a domestic violence survivor. I understand and respect the intent behind this bill. Protecting children from abusers should always be a priority. I want that for my own child. But I urge you to consider the other side of the issue. What happens when children end up in the hands of a manipulative parent who is in many ways the abuser? Section 5 of this bill as written risks giving even more power to those parents, those that use the legal system to punish the other parent, even when that parent has no history of abuse or violence, and in most cases had a great relationship with their child up until that custody case. My husband, a loving father and retired firefighter, has lost his connection with his children due to interference. My husband is the softest and kindest person I know. And I have recently experienced seeing my stepson struggle with the emotional wounds, anger, and hate because he has been manipulated against my husband. He tells him he hopes he dies. He tells him he's a fraud and worse. This is my family's everyday reality. And I'm not just reciting a study. I am living it. And I am watching helplessly as my husband, who dedicated his life to selflessly helping others, be destroyed. I have statistics, but I'm not going to read them. But I have also seen what happens when parents, despite their differences, encourage their child to love and maintain a strong relationship with both of their parents. I have the privilege of parenting a very well-adjusted and confident 12-year-old who loves both of his parents and both of his step-parents, including my husband. I wish I could share my photo of my son after running into my husband's arms after winning a national wrestling match. I wish you could witness my husband teaching my son to throw a football. That is the goal of any legislation concerning custody and parental rights, to support the best interests of the child, which includes protecting them from both traditional abuse and the insidious harm of parental interference. I ask you to carefully consider the impact of this bill and ensure it does not unintentionally strengthen the hand of a manipulative parent. Please do not hand power to false allegations. I recommend this bill not pass as written. At the very least, amend Section 5 to ensure those provisions are only enacted with proven abuse and ensure family counseling will not be affected or disallowed. Amend Section 7 to state that all of those listed also need training in parental alienation and interference. We must find a way to protect children from all forms of abuse, including emotional and psychological abuse of being manipulated into rejecting a loving parent. Thank you.
Thank you for joining us. Next caller in opposition, please.
Thank you, Vice Chair. There are no other callers for opposition at this time.
Thank you. We'll stay on the phone. Is there anyone wishing to join us in the neutral position for Senate Bill 257? Excuse me, 275.
Thank you. If you'd like to testify in the neutral position to SB 275, please press star 9 to take your place in the queue.
Hello?
Yes, we can hear you. We are in neutral.
Okay, thank you. I believe that I'm neutral because I am part of another state. I am part of the state of Colorado, but I have had the experience to.
And I can I just get your name for the record, please?
Sure. My name is Ana, A-N-A, and my last name is Soto, S-O-T-O. So I can specifically speak about the state of Colorado. I have been in family court for the past 2.5 years, and I can state the difference that Cadence law has made in our case. In our case has been allegations of abuse of a child that was strangled by his father, and because of the recanting the story of what happened to him out of fear for his father, he has been part of all the different psychological evaluations, forensic interventions, and school and CPS, and he told his story to all of them until he was in a specific supervised visit with the father, and was the only time that he took that away. And since then, the court was not able to hold accountable the father. Fast forward 2 years after, I had a permanent protection order that now I hold, and now I see how all of these elements that the Cadence law put in there, there's a reason of why, and when there's like a reasonable and real abuse allegations and safety reasons and concerns from the other parent, it can be extremely important that all of these different pieces hold in there. It is extremely important when baseless accused of no of parental alienation, that when abusers have these type of behaviors, they very few of them will take accountability and will take ownership of the way they are doing. And usually that is their ticket out of these situations. And so I think that all of this language that Cadence law has, that how this person has to take accountability before there's any remediation for them to have, again, any type of relationship with the parent that on their own hands damage this type of relationship is really important. It is really important that we start from the person that holds the power and that holds the responsibility to have our children safe, and it's us, our parents. So I can testify the importance that this law has done in a state like Colorado when they adopted most of the language of the law. And in our case, when has been domestic violence and these type of allegations, even when it was not a criminal finding, but there were domestic violence findings, this make a huge difference. And thanks to this, my children now have been having all the support that they need, all the psychological support, all of the safety, and you just see children that are resilient, that they have learned how to speak on their own, that they have been respected, and that they understand that their rights matter. Not only the parents' rights, but their safety and their rights matter. So I encourage to please, in the state of Nevada, to consider all of this language, because when there's a real concern, all of this language matter from the different fronts, and there's why there's these specifics in there. So thank you very much.
And thank you for joining us. Next caller in the neutral position, please.
Can you hear me?
Yes, we can.
Okay. So my name is Veronica York. I am a national domestic violence expert in the context of contested child custody cases. And I wanted to address a few of the current scientific research that supports that children who are exposed to domestic violence, trauma, and other child abuse will live shorter lives and face a lifetime of health and social problems. This comes from the ACE research, which is the Adverse Childhood Experiences from the Centers for Disease Control and Prevention. Fundamentally, without ACE, courts will minimize the impact that domestic violence and child abuse has on children. But more importantly, it states that most of the harm that's caused by domestic violence is not about any immediate physical injury. It is the stress and fear that abusers cause. The second study I want to mention is the Saunders study, which was out of the National Institute of Justice in the U.S. Justice Department. It was a study specifically to address the knowledge of domestic violence of judges, lawyers, and particularly custody evaluators. Fundamentally, without the Saunders study, courts will use the wrong professionals, as was stated earlier. In these types of cases, they turn to mental health professionals, custody evaluators, and again, they are not usually have the specific knowledge and expertise in domestic violence to recognize and respond correctly to DV and contested child custody cases. So without specific knowledge, which includes how to screen for domestic violence, risk assessment, post-separation abuse, and the impact of domestic violence on children, these professionals will believe the myth that mothers frequently make false reports, and they will use unscientific alienation theories. Ultimately, this leads to decisions and recommendations that harm children. So as an expert, one of the questions earlier was, who are the experts in domestic violence? Typically, advocates in DV are the experts. They're the ones, if you've had lived experience of DV, if you have worked with victims of domestic violence, these are the experts in domestic violence, and particularly if you understand the research behind domestic violence. There is a study called the BALA study, B-A-L-A, that specifically spoke to how frequently parents would make false allegations in child custody cases. And it found that mothers in child custody cases make deliberate false reports less than 2% of the time. In contrast, fathers in child custody cases are 16 times more likely to make false allegations. And again, this study was targeted to specifically child custody cases, because the bigger context is that most child custody cases are handled more or less amicably. It's only about 3.8% of all contested child custody cases that require trial, and often much more. And 75 to 90% of those cases are domestic violence and child abuse. So I just wanted to kind of give some of the background and research that we use as domestic violence experts when we testify in contested child custody cases.
And thank you for joining us. BPS, do you have anybody else wishing to speak in the neutral position?
There are no other callers wishing to provide neutral testimony at this time.
Thank you. And I don't see Madam Majority Leader. I don't know if we have any closing statements. Perfect. And I just wanted to indicate that I did get notice that obviously Madam Majority Leader will be working with everybody in opposition and hopefully address a lot of those concerns that were raised. It looks like everybody's in alignment with the objective. It's just a matter of making sure that the NRS reflects exactly those nuances in the legal side of it. But on the practical and objective, I think everybody's on the same page. So thank you. With that, we'll go ahead and close out the hearing on Senate Bill 275. Thank you to everybody who joined us today. We'll go to our final item on the agenda, which is public comment. Anybody wishing to speak for public comment, Carson City or Las Vegas? We do have somebody here in Carson City. Whenever you're ready.
Thank you very much, Chair and members of the committee. My name is Beth Smith, spelled Bethsmith, and I'm giving public comment today to raise awareness and ask for action on closing family court when matters of domestic violence are being discussed. So family court must be closed when domestic violence or abuse is being discussed, and that closure should apply to all related testimony and witnesses, not just from the victim or the accuser. Perpetrators of domestic violence should not be allowed to testify on the relevant matters of domestic violence. That public testimony is used as another method of abuse. And closing family court when discussing matters of domestic violence or allegations of domestic violence protects and benefits everyone by ensuring privacy while that matter is heard and considered. That's the accused, it's the accuser, it's the children, whether or not they're the subject of the abuse. It protects everyone. Domestic violence voyeurism has no place in Nevada's family courts. It's a violation of conscience, and we need protection by law following the Falcone decision, even with the other rulings that have partially clarified some aspects of Falcone. Thank you so much for your time.
And thank you for joining us. Anybody else wishing to join us for public comment? Seeing none in Carson City or Las Vegas. BPS, do we have anybody wishing to join us over the phone?
Thank you. If you would like to provide public comment today, please press star 9 to take your place in the queue.
I would just like to say one more thing. I've had a lot of things come to me after I spoke my comment, but
If I could have
if
you
you
please state your
can
name for
look
the
up
record. If I could have you state your name for the
Yes,
record. And just to be
sorry.
clear, we've already closed out the hearing, but anything that falls within the general purview of this committee is appropriate. Please continue.
Okay, Jennifer Garling, and Divorce Corp is something that everybody should watch to know that this is actually happening, and this is a real thing that's considered crooked in the court system. That's all. I just want everybody to know about Divorce Corp documentary.
Thank you for joining us. BPS, do you have anybody else wishing to join us for public comment?
Hello?
Yes, we can hear you.
Yes, this is Beatrice Aldevar again from Austin, Texas, and I would like to enter my public comment.
Okay.
Reunification camps are horrific. There's no place in family courts for reunification court methods. There's no place in family courts for the alienation, which is not even a scientific accepted method.
Ma'am, I apologize, but I am going to cut you off. We've already closed out the hearing, and we're not relitigating that hearing. But if you'd like to talk about anything else, please proceed.
Yes, I want to protect the children, and I would want no one to ever be a victim of what we went through. That's what I want to say. Thank you.
Thank you for joining us. BPS, do we have anybody else wishing to join us for public comment?
There are no other callers wishing to provide public comment. Excuse me, we do have one more caller.
Please proceed.
Hi, my name is Natalie Evans, and I just wanted to make the comment that there is no excuse for not protecting our children, and there's no excuse for not holding adults responsible for their actions and doing everything we can to require individuals with proper training and with proper background and understanding of the issues to evaluate these cases. I feel very strongly that when we make accommodations and accept individuals who do not necessarily meet the requirements in order to evaluate, we set ourselves up for failure, and we ultimately fail to meet the needs of our children and protect them. And I just feel that that is worth consideration during this hearing. Thank you.
All right, and we are in public comment. Do we have anybody else wishing to join us for public comment?
Thank you, Chair. The public lines are open and working. However, there are no callers to provide public comment at this time.
All right, thank you. And thank you everyone who joined us today. We will be meeting once again on Monday at 1 p.m. For those of us that sit on government affairs, we'll be starting in 9 minutes promptly. With that, thank you everyone. This meeting's adjourned.